Naga Peoples Front today filed an interlocutory application seeking intervention of the Gauhati High Court to restrain 7 of its dissident MLAs from entering Nagaland during the upcoming session. Earlier, the NPF had filed a petition with the Gauhati High Court challenging the July 14th order of the Nagaland Assembly Speaker dismissing their disqualification petition. The MLAs against whom the IA is filed include EE Pang Tiang Kejong Chang, CL John, Ishak Konyak, BS Ngang Lang, Toyang Chang and N Thongwang Konyak. Advocate Siddharth Borgohain, representing the NPF, said that they are not happy with the NLA Speaker's ruling as the Speaker had passed the judgment without looking at the evidence. The final hearing of the interlocutory application and the writ petition has been fixed for the 8th of February.
So, can you briefly tell us about the hearing of today?
No, as I told you, we have filed an interlocutory application praying the Honourable Court for restraining those 7 MLAs, respondents, from entering into the Assembly, for taking part in the Assembly, which is to be held on 12th of February, that's Friday. And the reason behind is that the matter is delayed for a considerable period of time. And as I have said before also, that the disqualification petitions are to be heard and disposed of by the Speaker within 3 months. And that is the law of the land. Now question arises is that this matter was pending before the Speaker for more than 13-15 months. And now the matter is pending here before this Honourable Court. So a substantial question of law was raised in this petition, that if the Honourable Apex Court says, the highest judiciary says that any disqualification matter filed before the Assembly Speaker, it has to be decided within 3 months. Now the question is that if anybody is affected with the judgment or not satisfied with the judgment of the Speaker, they will assign this same thing before the Honourable High Court. Now the question is that whether the Honourable High Court will decide the matter also in a fixed time frame, because time frame you cannot compartmentalize or segregate the justice dispensing system, that a particular body will decide the matter in a particular time, and as far as the other part is concerned, whether there is a particular time frame to decide or not. That is the question.
Judgment of the Speaker, how do you find it?
We are not happy. That's the reason we came before this court, because we find the judgment to be basically perverse judgment. Because with no reason, without looking at the evidences, rightly appreciating the evidences, pass the judgment. So that is the reason why we came to this court, and that is the reason the Honourable Court on 23/7/2020, if I am not wrong, my particular date, the division bench took cognizance of this matter. So the merit of the judgment itself is a question mark.